evening, everyone. So welcome to the symposium on the law and politics of unconstitutional constitutional amendment in Asia. So I am Bùi Ngọc Sơn, assistant professor here at CU HK Law. So I will be the chair of this panel. So in this panel, we have three speakers. Our first speaker is Professor Koichi Nakano, Professor of Political Science and the Dean of the Faculty of Liberal Arts at the Sophia University in Japan. And he will discuss the politics of unconstitutional constitutional amendment in Japan. And our second speaker is Professor H.B. Lee from Monash University, Faculty of Law in Australia. And he will discuss the presentation and we present on the basic law doctrine in Malaysia. And our third speaker is Dr. Kem Tong Thonsakurungrang, a lecturer from Chulalongkorn University, Faculty of Law. And he will present on constitutional amendments, unamendability, and constitutionalisms in Thailand. So welcome all. So after the presentations, you participants of this panel can unmute yourself and ask the question directly. And for all the participants, you can send your questions or comments to me, and I will pass to our presentators. So now, without further, so I will pass the floor to Professor Koichi Nakano. Koichi, the floor is yours.
Thank you, Son. I hope you can all hear me okay.
Yes, okay.
Yeah, thank you, Son, and thank you, Rehan. And thank you, everybody at the Chinese University of Hong Kong. I'm very honored to have this opportunity to address to you all. But at the same time, I have to say I'm a little bit embarrassed and feeling awkward because I'm probably and possibly, I think, the only political scientist in the group. I don't have legal training, and I came to the subject of constitutional revision in Japan almost by accident as the controversial changes of the interpretation of the Article 9 of the Japanese Constitution took place recently in 2015 with the rather well-known security legislation by Prime Minister Abe at the time, lifting the ban on the exercise of collective self-defense in post-war Japan. So you have to forgive me my rather unorthodox background in yesterday and today's discussions. And plus, yesterday I had a full load of classes and meetings, so I was only able to take a peek of the exchanges a little bit, but I very much enjoyed it, and I hope to learn more today. So let me share a screen with you, and I hope you can see it okay. This is the subject of my presentation today, the politics of unconstitutional constitutional amendment in Japan, the case of Article 9. Well, first about Article 9. You have the full text of Article 9, 2 paragraphs, translated in English by the, this is the official English translation of the Japanese Constitution, Article 9. So, aspiring sincerely to an international peace based on justice and order, the Japanese people forever renounce war as a sovereign right of the nation and the threat or use of force as means of settling international disputes. The second paragraph is, in order to accomplish the aim of the preceding paragraph, land, sea, and air forces, as well as other war potential, will never be maintained. The right of belligerency of the state will not be recognized. So as you can see, this is a rather sweeping ban on war and on war potential that Japan has lived with ever since the post-war. The law, the constitution, as you probably are aware of, was adopted, well, actually, it was formally speaking a revision of the so-called Meiji Constitution. I think there was some discussion about yesterday about goti. The Japanese term for that is kokutai, The pre-war constitution of Japan had this notion of kokutai, which was abused by the militarists to essentially impose the militarist rule under the name of the emperor. So the term kokutai is very much a dead word in post-war Japan, so it was quite interesting to hear that the term in each of the language, in different language in Vietnam as well as in China, was being utilized in today's context as well. Anyway, so this is Article 9, and this is the Constitution. Well, this is probably the most famous article of the post-war Constitution of Japan, which was implemented from 1947. So the Constitution has never been amended. I think it's the longest unamended Constitution in the world that is actively in use. The only longer unamended constitution, I think, is the Italian Republic's constitution, which has, of course, which has since become unused. Well, even though Article 9 itself is rather sweeping in renouncing war and war potential, there was Cold War reality very soon after the Constitution was put in place. First, Japan regained independence by signing the San Francisco Peace Treaty in 1951. And at the same time, in fact, on the same date, the then Prime Minister Yoshida signed another treaty with much less fanfare, and that was the US-Japan Security Treaty. It bears noting that the San Francisco Peace Treaty did not include, for example, the Soviet Union or the People's Republic of China as a signatory. And of course, South Korea or North Korea were also left out, given that they were former colonies of Japan and not a belligerent country in that sense. So the controversy starts right from there. And the fact that Japan was allied with the United States in the context of the Cold War, in reality, of course, the US bases were kept even after the Japanese independence in 1952. And so Article 9 needs to be sort of understood at the same time as being in the context of Japan's alliance with the United States, very much under American protection in the early decades of the Cold War. At the same time, and also in relation to America, there was considerable American pressure almost as soon as the Cold War began in earnest. And of course, Cold War in Asia, East Asia, has to do with the PRC establishing the Beijing government, and also followed by the Korean War in the Korean Peninsula. Both these things, of course, have had a huge impact on the American security strategy against the communist bloc in East Asia. And in some ways, you can say that almost as soon as the post-war constitution came into place in Japan, the Americans started to have a second thought. And so there was almost immediate pressure from the United States on Japan to start to rearm in spite of Article 9, which is kind of ironic because, of course, the Japanese wing in particular argued that this is an American-imposed constitution. But the reality is closer to the fact that the US wanted Japan's rearmament almost as soon as the 1950s began. Initially, the Japanese rearmament began as sort of boosting the police force by setting up the police reserve. And already then, some of the former military officers, personnel, entered the police reserve. National Safety Police Force was established out of the police reserve, and in 1954, National Safety Force became the Self-Defense Force. today known as the SDF of Japan, Japan's quasi-military, under the context of Article 9. And well, the Japanese government, in the context of the Cold War, soon came around to argue that in spite of Article 9, Japan can exercise individual self-defense. That Article 9 does not mean that Japan abandoned its right of self-defense, and it is able to exercise individual self-defense, and therefore self-defense force is constitutional. That is not against Article 9. The Japanese government, however, eventually established what is called the 3 conditions for the exercise of individual self-defense. The first condition is that Japan needs to be attacked first. Japan has to be under military attack or is invaded. And then the second condition is that, well, Japan exhausts all means available to get rid of the invading forces through diplomacy. And having failed both the second condition, Japan may exercise force in the minimally necessary extent. So these are the 3 conditions under which the post-war Japanese government argued that in spite of Article 9, Japan can exercise individual self-defense. And therefore, self-defense force is constitutional. Let me also touch upon Article 96 before I go further. Article 96 is the article that stipulates the conditions under which the Japanese constitution can be amended. Amendments to this constitution shall be initiated by the Diet through a concurring vote of 2/3 or more of all the members of each house, and shall thereupon be submitted to the people for ratification, which shall require the affirmative vote of a majority of all votes cast thereon at a special referendum or at such election as the Diet shall specify. Amendments, when so ratified, shall immediately be promulgated by the Emperor in the name of the people as an integral part of this constitution. So, in short, in order to formally amend the Japanese constitution, you need to have 2/3 majority in both houses, and then you need to also have that ratified in a popular referendum of a simple majority of all the votes cast. As you can see, it's a constitution that's relatively hard to amend, and it's been cited by those people who are in favor of amending Article 9 as an obstacle and as too high of a hurdle to actually realistically amend the constitution. Well, that's not the entire story, and I wanted to highlight in my draft paper the fact that Article 9 came to gain growing support in the context of the Cold War. I do caution you, however, that this is not Article 9 in the strict letters of the text, but it's more the reality of Article 9 under Japan's alliance with the United States and with the existence of self-defense force. Well, the question, should Article 9 be revised, has been asked in various polls consistently over time. And of course, the actual ways in which the polls are conducted changed a little bit over time, but I think we can still usefully look at the numbers for comparison. This is a set of polls from the Asahi newspapers. In 1959, so very soon after Japan's independence, when the question was asked, you can see it's a tie, it's a virtual tie. In fact, the remaining 30% of the people answered, I don't know. So the Japanese public opinion was divided in 3 completely, more or less evenly. But what is interesting is that as the constitution experienced sort of life in the real context of the Cold War, by 1957, the number of people who said that the Article 9 should be revised remained more or less stagnant, or just 1% increase, whereas there is a 20% jump in the no campaign on the no side. In other words, those people who couldn't make up their mind in great majority seems to have moved to supporting Article 9 and not wanting to have it changed. Which is interesting because, of course, you probably have heard that Article 9 is rather well supported by the Japanese public, and that is not untrue. But at the same time, in the immediate post-war, obviously not every Japanese was a war-repentant pacifist. A lot of people actually have thought that this was an American imposition, that Japan should regain full sovereignty and it should rearm itself. But over time, the Japanese people started to feel more comfortable with Article 9 in the context of Japan's alliance with the United States and with the existence of the minimal self-defense force. So as you can see, in 1962, the yes camp has 26%, so it's a continuous decrease, whereas the no camp has 61%. And by 1978, I think this period is around the period where the support for Article 9 was at its strongest. The no side has 71%, and the yes camp is diminished to a mere 15%. So these are rather significant conditions that actually made it impossible for the conservatives to even think of revising Article 9. So to say that this was simply because of Article 96 that the Japanese constitution has never been amended is simply not true. It's because that the conservatives thought that this was not in their partisan interest to pursue the revision of Article 9. It's just a dead cause. However, things started to change as the Cold War came to an end, and there's been what I call the neoliberal turn of constitutional reform debate. A significant development was the year following the fall of Berlin Wall. And many of you would probably remember, unless you are too young to remember it, the Gulf Crisis and the Gulf War. It's sometimes referred to in Japanese in katakana as trauma, the Gulf Crisis or Gulf War trauma, because the ruling elites of Japan, both in politics and in the bureaucracy, were very much traumatized by the sequence of events. You need to also remember that back in the late 1980s and early 1990s, Japan was in the height of the so-called bubble economy. People used to talk about Japan at the time like they talk about China today. There was also a best-selling book by the Harvard professor Ezra Vogel entitled Japan as Number One. There was even talk about Japan overtaking the United States militarily, and there was this sense that Japan made it, and Japan is an economic giant, and it should also become more influential politically and perhaps even militarily. However, when the Gulf War occurred, because of the constraints imposed on Japan by Article 9, the Japanese conservatives were unable to take part other than spending a lot of money that went into the American pocket. And at the end of the day, one famous episode is that when the Kuwaiti government was restored and it put a one-page advertisement on the International Herald Tribune thanking the governments that helped Kuwait to become independent again, they forgot to mention Japan. Even though Japan paid a huge amount of money, essentially that went to the US government. It was called too little too late. And since then on, the conservatives have really set their eye on trying to change or overcome Article 9's constraint. At the same time, following the lead taken by Margaret Thatcher and Ronald Reagan, Japan too, in the figure of Prime Minister Nakasone in the mid-1980s, Japan embarked on the neoliberal reforms of bureaucracy and governance, electoral system, and regulatory frameworks. Because Japan is a parliamentary system, in terms of the system of politics and of administration, Japan, the conservatives in particular, but political elites sought to remodel Japan after the United Kingdom, Britain, the British model of one-party government, with two-party system under the first past the post system in terms of electoral system. And in terms of the economy, also modeling after Margaret Thatcher and Ronald Reagan, deregulation and trying to curtail the power of the almighty state. That neoliberal internationalist orientation was reflected also in the discussions that have to do with the constitution and also of the security policy arrangement. Ozawa, a very influential figure who's still not retired from politics even today, though much diminished compared to his the peak of his influence in the 1990s and the 2000s. Ozawa, who was initially a strong man in the ruling LDP, preached a UN-centered normal country thesis, that Japan should overcome the post-war constraints, Article 9 in particular, and it should become a quote-unquote normal country. I leave it to your judgment whether Britain is a normal country, let alone if America is a normal country, but the argument was that Japan should become a normal country like the US or Britain, with full sovereign rights over defense and security arrangements. At the same time, Ozawa pioneered criticism against the Cabinet Legislation Bureau. Cabinet Legislation Bureau is an arm of the government of Japan that consists of bureaucrats, career bureaucrats with legal expertise. And in the post-war period, they established a monopoly control through convention to offer the official government interpretation of the constitution and of the laws. And Ozawa started to argue that it was odd for the bureaucrats in the Cabinet Legislation Bureau to be able to say that Article 9 should be interpreted this way, and it doesn't allow Japan to do certain things that Ozawa thought Japan could do. Finally, the PKO law was passed in 1992, and this opened a new era for the Japanese politics in terms of opening up new ways of engagement overseas. Japan started to take part in UN-sponsored peacekeeping operations from then on in Cambodia and in Africa and elsewhere. In this era, there was also a flourishing of so-called future-oriented and multifaceted constitutional reform debate. This is a change of tactic on the part of those people who are advocating the reform of Article 9. They realized that a narrow focus on Article 9 doesn't sell, and so they were trying to argue that Japan should change other parts of the constitution or insert new rights like the right to a clean environment or the right to know in the constitution. And there was an interesting development there that served to push people to come to think that constitution should be amended without putting the finger on Article 9, although the intention was pretty clear. And you can see these changes taking place here. Newspapers came to support for the revision of Article 9, the conservative Yomiuri in 1990, Nikkei, the financial paper in 2000, they started to argue that it's high time Japan changed Article 9. You can see in Asahi polls, constitutional revision, for the first time in 1997, a greater percentage of the respondents said that the constitution should be revised. Although when asked about Article 9, still an overwhelming 69% of people said that, well, Article 9 should not be changed. Business sector support for Article 9 revision also followed in 2000s. JACE stands for Japan Association of Corporate Executives. This is a more right-wing, more neoliberal business association that consists of business executives in their individual capacity. They were the first to spearhead the move. Keidanren followed in 2005, and the Japan Chamber of Commerce and Industry also in 2005. Each of these organizations issued their own report for constitutional revision that included the revision of Article 9. And significantly also, there's been a real change in the party politics in Japan. The Japan Socialist Party, JSP, which has been the main opposition party and dead set against the revision of Article 9, collapsed. And it was replaced eventually by the DPJ, the Democratic Party of Japan, as the main opposition party. But the DPJ, it was much more centrist and included proponents of the revision of Article 9 or the Constitution in general. It's a mixed bag of people, centrists, some moderate conservatives, and some former socialists. And in 2005, they started to discuss their own version of constitutional revision proposal. You can see here a set of changes that took place from 1996 to the 2000s. And I list them there because up until the mid-1990s, the Japanese socialists were also in government, even though they were becoming weaker. The LDP starts to get fuller control of politics from 1996. And following that, there's a set of measures that were pushed by the United States and by the desire of the Japanese conservatives to harness the US, because there was a fear shared by the South Korean leaders at the time as well, that in the context of the post-Cold War, America may withdraw from East Asia. And in order to entice the US to stay in East Asia, the Japanese conservatives started to concede much more vigorously to the American demand and to coordinate security policy under American umbrella. And to such an extent, by the time Koizumi stepped down, he made these remarks. There's no such thing as US-Japan relationship too close. Some people maintain that maybe we should pay more attention to other issues, but he says the US-Japan relationship, the closer, the more intimate it is easier for us to behave and establish better relations with China, with South Korea, and other nations in Asia. In other words, Koizumi said the unspeakable truth that was in the mind of the many conservatives, that the Japanese government needs to worry about the US. It doesn't really need to worry about Asian countries. In 2005, Japan's LDP also put forward its first proposal for a new constitution. I'm running out of time, sorry, so I'm kind of going fast for the remaining slides. The Asahi poll shows in 2005, constitutional revision, there is 56% yes, but still Article 9, there is a stronger element of no. The first government of Abe comes in. In fact, Abe has the effect of pushing the opposition to Article 9 revision to stronger point because he worried people. The DPJ government put an emphasis on political leadership and sidelined the Cabinet Legislation Bureau, without playing a key role now in opposition. The LDP shifted to the right while he was in opposition, and that had strong implications because when Abe came back to power, he initiated all these changes. He revived the Prime Minister's Council on Security Legislation. He also tried to change Article 96 unsuccessfully. He also made a political appointment to the Cabinet Legislation Bureau, and he imposed his own interpretation, lifting the ban on collective self-defense in 2014. And after having addressed the US Congress, and after having made a speech in the Shangri-La dialogue that he's going to do it, he pushed through the security-related laws that lifted the ban on the exercise of collective self-defense. So this is the last slide that I have here. History of informal constitutional amendments in Japan. The Cabinet Legislation Bureau moderated the process, but Article 9 in the post-war period, during the period of the post-war, in the Cold War era, was still remaining within the boundary of what was justifiable. Article 9 was not deprived of all meaning, even if Japan was able to exercise individual self-defense. However, that changed under American pressure in the post-Cold War setting. There was a precedence of international American pressure over domestic legal and political processes, and the potential and real weakness of the Cabinet Legislation Bureau and the courts as the guardian of the rule of law and constitutionalism came to be exposed. There's also been a significant change toward the neoliberal authoritarian form of governance. Sometimes the British political system is nicknamed as elective dictatorship, and Japan came close to that, even though it has a written constitution. The government can now freely reinterpret constitution because of the control over the Cabinet Legislation Bureau. The Japanese government under Abe also took control of the Bank of Japan, NHK, the public broadcaster as well. And finally, amendment of cabinet decision and the law rather than the constitution itself. So instead of formally amending the constitution, Abe de facto amended the constitution by imposing his cabinet decision, new interpretation of the constitution and the law. But there's contestation and uncertainty that's still persistent. So people like Abe and the people who want to rearm Japan fully, they continue to have an ambition for a post facto formal constitutional amendment. And that is, of course, to admit that the way of doing it is not constitutional or is illegitimate. There is also persistent public and expert contestation against the cabinet decision and the security legislation. Thank you.
Son, you're muted.
Sorry. Thank you, Koji. Very interesting story about Japan, especially the idea about unconstitutional, informal constitutional amendment. Professor, it is your turn. Professor Lee, can you unmute yourself?
Can you hear me now?
Yeah, yes. Okay.
All right, thank you very much, Son. Hello, Rehan. I will just comment on some essential features of the paper which I had earlier submitted, rather than to go through the fine details of the paper. In the first place, my paper is entitled The Basic Structure Doctrine. And initially, as was advertised, it talks about a rising trajectory in the Malaysian constitutional jurisprudence. Over the course of time, I've decided to change the word a rising to the rising trajectory in Malaysian constitutional jurisprudence, for the simple reason that I have come to the view that the basic structure doctrine is now a fully entrenched part of Malaysian constitutional law. To appreciate that particular development, let me give you some essential aspects of the shaping of the Malaysian constitution. It came into being in 1957. The constitution was the product of a panel of experts. All these experts came from outside Malaysia, which is very unusual for constitutional development. But in one sense, by having a panel of experts who were appointed from outside Malaysia, the panel brought to the deliberation an impartial mind and look at the constitutional bargain which would enable a new nation to be born. And we have a panel headed by one of the most well-known jurists of the time, Lord Reed. In that panel was Ivor Jennings. So it was a very high-powered constitutional commission. It drew up a constitution for a birth of a nation, which had got 9 Malay states and the strait settlements of former strait settlements of Penang and Malacca. In terms of the place of Malaysia in the constitutional spectrum of countries in the region, it is a remarkable achievement in that when you look at Malaysia, it came into being in 1957. And since that birth of the nation, the civil power has never been usurped by the military. And for the first time, we find in 2018, a transition of government without riots in the street. And there was a remarkable change of government after 60 years of dominance by a ruling coalition. But during that particular shaping of the nation from 1957 onwards, because of the dominance of the ruling coalition, in which the main partner was the United Malay National Organization, it enabled the government to resort to the amendment power in the Constitution to make drastic changes to the Constitution. And over that period of time, many constitutional amendments were made. And this was possible because as a result of the dominance of the ruling coalition, they were able to exploit the amendment formula in the Constitution. The amendment formula was very simple. To amend the Constitution, you need to have a law which is passed by a two-thirds majority in the lower house of parliament and by a two-thirds majority in the upper house. So that if there is a dominance of a political party, it was quite easy for the government to achieve the two-thirds majority to amend the Constitution. And right from the very beginning of independence, a few years after that, the government amended the Constitution to enhance the power of the executive, to diminish the safeguards in terms of constitutional protection to fundamental liberties. This was also shaped by the fact that the judiciary, which was supposed to be the guardian of the Constitution, over the course of time, lost its standing as a truly independent institution of government. And it all came to a head in 1988 when the top judicial officer of the land, who was then known as a Lord President, was dismissed from office during the time, during the time when the Prime Minister was Dr. Mahathir. As a result of the dismissal of the top judicial officer of the land in 1988, we find the judiciary declining in terms of independence, in terms of the trust placed by the people of Malaysia in its ability to dispense the law without fear or favor. And then the judiciary over the course of time was embroiled in a number of controversies and scandals, to the extent that there was even a royal commission which was conducted to look into the perceived failings of the judiciary. With a weakened judiciary, with a parliament which was basically dominated by the ruling party, there was no problem insofar as amendments to the Malaysian Constitution was concerned. It was inevitable that at some stage, unease with the ability of the government to alter this fundamental document of the nation would lead to queries about whether there could be some form of implied restriction or limitation on the power of constitutional amendment. In 1963, there were moves to enlarge the federation, and the Federation of Malaya then became the Federation of Malaysia, with the addition of two new states from Borneo, Sabah and Sarawak. and also Singapore. But Singapore stayed only for 2 years before it was ejected from the Federation in 1965. But what is significant is on the very eve of the birth of the new Federation of Malaysia, a constitutional challenge was launched in which the state, one of the Malay states, the state of Kelantan, argued that the constitutional amendment was invalid, the amendment being to enlarge the federation by the admission of the new states was invalid because it failed to obtain the consent or the approval of the Malay ruler of the state of Kelantan, and there was no consultation with the state of Kelantan. Well, this case was dismissed by the judge, by the court. But what was interesting is that the Judge Thompson, in the deliberation and in the delivering the argument, the judgment, said that there was nothing fundamentally revolutionary that would require consultation with the state of Kelantan or with the Malay ruler. From there, it was argued that there was a glimmer of a prospect that there could be some implied limitation or restriction on the power of constitutional amendment. That is, if an amendment of the Constitution could be described as effecting an amendment which is so fundamentally revolutionary, then possibly there could be a requirement of other requirements which are not dictated by the express words of the Constitution. However, my view is that although some commentators have alluded to this notion of fundamental revolutionary changes as echoing the basic structure doctrine of the Indian Supreme Court, my view is that that particular notion opened by the court in that particular case was only confined to a particular scenario in terms of enlargement of the federation from 11 states to 13 states. I don't think that the court put its mind to the development of a basic structure doctrine. And in fact, that case preceded the Kesavananda case, where the basic structure doctrine of the Indian Supreme Court was established. Further attempts were made down the path where arguments were raised trying to persuade the court to be receptive to the idea of transplanting this Indian basic structure doctrine into the Malaysian legal arena. And in my paper, I refer to some cases like Loh Kui Chun and Pang Sin Hock, where the court basically dismissed this idea of the basic structure doctrine. Although other commentators have said, while the court was not receptive, it did not expressly reject this particular doctrine. But what is fascinating now is that over that period of since 1957, the ruling coalition started to lose its grip on power. And then we find in the 2018, the ruling coalition lost control of the government to a coalition which was led by Anwar Ibrahim and with Dr. Mahathir as part of that particular coalition. 2018, therefore, represented a significant point in the constitutional history of Malaysia, where a golden opportunity was made available for the Malaysian nation to institute constitutional reform to strengthen the various institutions, the independence of the judiciary. But that particular opportunity was unfortunately squandered by the struggle between Dr. Mahathir and Anwar Ibrahim. And today we know that the Pakatan coalition has lost control of government and is now back in the hands of a coalition involving the former UMNO and the linking arms with the Islamic Party, and with a few people who jumped ship from the Pakatan, and now they are controlling the reins of power. But my point of indicating this political development is that as you see the diminishing control on power of the ruling coalition, you find an increase in the assertion by the judiciary of its power to reinstate its lost prestige and its lost independence. And in my paper, I drew attention to the landmark case of Semenye, in which the court in Malaysia has basically embraced the basic structure doctrine. But to understand that particular development, one have to look to an earlier case in relation to an amendment to the Constitution, which is an amendment to Article 121 of the Constitution. Just like many other constitutions around the world, you'll find that the vesting of powers, like the legislative power, is expressly stated to be vested in the parliament. The executive power is expressly stated to be vested in the executive. Likewise, in Malaysia, the judicial power of the federation is stated expressly to be vested in the high courts of Malaysia. But in 1988, a constitutional amendment was effected at the time when Dr. Mahathir was the prime minister. He was annoyed with a number of decisions of the court, and he therefore effected a change to the constitution. Instead of saying that the judicial power of the federation is vested in the high court, etc., it now states, as a result of the amendment, that the high court and other inferior courts shall have such jurisdiction as are vested in it by statute. In other words, Parliament now has a controlling say in the jurisdiction of the court. There were two possibilities in terms of that amendment. One is a possible interpretation in which the court could boldly reassert their dominance by reading down the construction of that amendment. But in a remarkable act of self-emasculation by the highest court of the land, headed by the Chief Justice, who then basically said that as a result of this constitutional amendment, that amendment must have significance, that amendment must have effect, and therefore the court of Malaysia were to exercise jurisdiction, only those jurisdictions as are conferred upon it by the parliament. In other words, now the courts are at the mercy of the parliament. And that's why when we looked at this case of Semenye, Semenye could be regarded as a very important and a landmark case in Malaysia, because the court now has reasserted its dominance in terms of its independence as a judicial institution. The court in Semenye's case embraced the basic structure doctrine and said that some of the basic structure of the Malaysian Constitution includes the rule of law and emphasized particularly the separation of powers. Now, once you accept that the separation of powers doctrine is an essential feature of the basic structure of the Malaysian Constitution, then inevitably and logically, any constitutional amendment which violates the separation of powers doctrine would be unconstitutional. But when you look at Semenye's case, the court did not go to the logical step of rendering that constitutional amendment unconstitutional. It stopped short. But it argued that the constitutional amendment did not have the effect of depriving the court of its inherent jurisdiction. Now, many people have argued that this is a bold decision of the court and that it has restored the judiciary in its proper place within the constitutional framework. But there's one worry. Because that basic structure doctrine is applied, and it's only applied in terms of reading down the constitutional amendment, there's nothing to prevent a future court where you may have a compliant Chief Justice who feels indebted to the government of the day to alter the interpretation and to change the interpretation back to the original one where the Chief Justice adopted an interpretation of self-emasculation. So my hope is that down the track, the judges would have the courage and integrity to maintain this basic structure doctrine in Malaysia. And it appears to be so because the further cases in my paper supported the bolstering of the adoption of the basic structure doctrine in Malaysia, so that we can now confidently say, as a result of a combination of these few cases, that the basic structure doctrine has successfully been transplanted from the Indian Supreme Court jurisprudence into the Malaysian constitutional jurisprudence. But what are the problems? Well, the problems are that we do not know what are really all the essential features of the Constitution which fall within this notion of basic structure. The court has tossed up the possibility of the rule of law, the separation of powers, and in one judgment, there was a reference to the protection of minority rights and the fundamental liberties. But in my paper, I refer to two situations where the basic structure doctrine has been raised, where in one particular situation where the basic structure doctrine has been raised in argument, and the other one where I have argued that logically, if that basic structure doctrine is to be applied, it could render invalid an amendment to a particular provision to the Constitution. That particular provision in my paper is an amendment to Article 150 of the Constitution. Now, that article is an article which confers upon the king the power to declare a state of emergency. And we all know that in many developing countries, the constitutional power to declare a state of emergency has been exploited, basically, for the government to retain its grips on power. In an amendment to Article 150, a new clause was added to 150, Clause 8, which basically precludes the court from exercising any form of judicial review in respect of a proclamation of emergency. My argument in my paper is that if the basic structure doctrine is adopted, and that the rule of law is one of the basic features, and the separation of powers is an essential feature of our constitutional basic structure, then logically, Clause 8 to Article 150 must be unconstitutional. And hopefully, a day may come when that possibility may arise for the court to consider it. The second scenario is the question of, is the assent to legislation given by the King of Malaysia to federal legislation, or the assent given by the state ruler to state legislation, is that an essential feature which falls within the basic structure? Well, that argument has been raised because in a constitutional battle between the Mahathir government and the Malay rulers or the sultans in 1983, in 84, the constitution was amended because there was a fear at that stage that the Malay rulers may make life difficult for the government by withholding assent to legislation unless their wishes were complied with. So the Mahathir government launched a major battle with the rulers and ram through constitutional amendment, which basically, if I could put it at its very simplest form, at the federal level, if the king does not give assent to the legislation, that assent will be deemed to have been given after a lapse of a prescribed period. I think it's 15 days or so. Now, can one argue that by basically deeming the assent to be given, it has abrogated the assent of the king? And if that is so, is that an abrogation of an essential feature of the Constitution? Well, a case was brought before the court by Anwar Ibrahim, but the court dismissed the case without really rendering a judgment on the issue. Although in passing, one of the judges appeared to say that there was actually no major significant alteration. The assent is still there, even though it is deemed to be given. But in my view, it was a flawed decision because the judge assumed that the assent to give, the royal assent to legislation is an essential feature. And I do query whether one should accept the proposition that royal assent to legislation is an essential feature. After all, there is no fixed formula as to the composition of parliament. Parliament can be changed from a bicameral parliament to a unicameral parliament. So that if you can alter the elements of the parliamentary institution, and assent is one of the elements, there's no reason why one should accept the proposition that royal assent to legislation is part of the basic structure of the Constitution. And I conclude my paper by saying that when you look at the shaping of the Malaysian Constitution over the course of time, one, I think, is heartened by the fact that now there is evidence that the court is showing greater courage and independence in reasserting itself as an independent institution within the constitutional framework. But as I quoted Professor Andrew Harding towards the end of my paper, applying the basic structure doctrine may require the application of a judicial instinct. And I concluded by saying, I hope that the judiciary's instinct is right. Otherwise, they can pay a heavy price in terms of political repercussion. Thank you.
Thank you, Vasily, for this wonderful presentation on the story of unconstitutional constitutional amendment in Malaysia, especially the amendment about judicial independence. So our next speaker is Kem Thong. Hello, Kem Thong.
Hi. Okay. Hi, Son. Thank you.
Hi. Okay.
Thank you very much, and greeting everyone. Nice to see all of you here. Can you hear me all right?
Okay.
Okay, thank you. I would say the topic is very apt for Thailand at the moment because Bangkok is broiling and there's a debate about constitutional amendment going on in the parliament right now. Okay, so let's see. Let me share the screen. Okay. So it's the politics of unamendability in Thailand, and it's the politics of what I call two democracies. And the period of my study is 2011 to 2014. And the most important message in my study, in my article, is that the principle of unamendability in Thailand is invoked not to safeguard liberal democracy, but to perpetuate or to entrench authoritarianism under the pretext of Thai-style democracy, which I will elaborate in my presentation later. So first, let me give you context of the 2011-2014 period. So it is a rare moment in Thai politics because that period was sandwiched between the two large street protests and two coups d'etats. It was the time of civilian government. So that amendment could take place because there's no military intervention, and any constitutional change were tried through a more lawful means. Okay? The governing law at the moment was the 2007 Constitution. It is now ceased to exist because of the 2014 coup d'etat. But at that time, it was the governing constitution of Thailand. And it is called the unpopular constitution for a very good reason. First, it was the product of 2006 coup that ousted Thaksin Shinawatra, one of the most popular prime minister of Thailand of all time. And the content, it was hastily drafted within over a few months. It had little public participation, and the content is, I would say, problematic too. But it tried to boost its democratic legitimacy by requiring a national referendum on the constitution. And during that referendum, a lot of key figures in the coup regime knew very well that many people want to reject the draft. So they promised that just do it strategically, that you can vote, accept the constitution, and you get rid of the military government, you get the election and democratic government, and then you can amend the law. So that was a promise that made a lot of people vote for the constitution. The outcome was like 50-48, something like that. So it's not like a very decisive victory. But anyway, that referendum give this constitution a democratic boost, really. And despite knowing that there's a probability of this law being amended, actually the 2007 constitution require only I would say fairly easy amendment procedures. So it needs absolute majority. So more than half of all the members of both houses. There's no referendum required for the amendment. So that's one difference from the drafting of a new one that you require one. And there's already an explicit unamendability imposed in the law. So Thailand has to remain one single indivisible kingdom. So there's like just only one explicit unamendability that the amendment couldn't turn Thailand into the republic, for example. Yeah. But between 2011 and 2014, it was the time of Yingluck Shinawat's administration. Yingluck was Thaksin's youngest sister, and she is the first Thailand's female prime minister. And the whole agenda, she turned it into the electoral campaign. She promised the public that she will amend the constitution, and the public vote her in to become a prime minister. And what do they want to amend exactly? They want to amend what I call a pain points. So all these, the undemocratic origin, the lack of public participation, the senatorial election, the party dissolution, the treaty making power. So details are in the paper, but just run through the topic. In essence, the series of amendments that Yingluck and her voters wish for aims at returning from the 2007 constitution to a more popular 1997. The biggest difference between the two constitutions is that in 1997, the constitution want a strong leadership. So they strengthen leadership of the prime minister through many mechanisms. Why in 2007 constitution, they want to weaken the leadership because they are afraid of what we call a parliamentary dictatorship. So a lot of new mechanisms are installed. For example, the Senate election turned into a Senate appointment. So you can argue that an election is prone to like vote buying, but a lot of people dislike this constitution, argue that and by appointment it's susceptible to lobbying, secret lobbying. So there's a lot of argument, but all in all these points that Yingluck proposed is trying to turn it back to a more popular 1997, where the prime minister has a stronger power and stronger leadership to lead the country. So there are four cases in the court, and all these cases are problematic in their own way. Okay, for example, actually, there's no state bodies that can review the amendment, the constitutional amendment. So the constitutional court can review normal legislations, but no court actually, and not even the parliament can review the constitutionality of the amendment proposal. But anyhow, the right wing the right wing conservative filed a challenge to the court, and the court accept it under a very vague clause. That clause stated that anyone who witnessed an act to overthrow a democratic regime with the king as the head of the state can petition to the attorney general, and the attorney general will petition to the constitutional court to order a cease and desist order. What happened is that when the right-wing activists filed the case, they filed directly to the constitutional court. They just bypass the attorney general, and that's a clear breach of procedures. Anyhow, the court say that that's fine, we're gonna accept it. So this is not about the content of the unamendability, but it just shows that the court is very willing to try this case and show the court's prejudice against the government as well. So the first case that came in is when Yingluck tried to do what I call the wholesale amendment. So Yingluck proposed to amend the amendment procedures, to abolish the amendment procedures, and to set up a new constitution drafting council represented by a representative of every region, every province in Thailand. So that's something that 1997 constitution did, and people really like the idea of having the representative from the direct election sitting in the convention. Anyhow, the court said that there's a distinction between a normal amendment and an amendment in this grand scheme. So the court seems to recognize that this is not a normal amendment that go through each section, but this is actually a replacement of the whole constitution. So the court suggests, the court didn't rule in this case. The court didn't rule. The court merely suggests to the government that they might need they might need more public input. In a way, the court said that because this is more similar to a primary constituent power, so you have to follow the same procedures that constitute this constitution, which means that the court is suggesting a national referendum. So there was a discussion about impeaching constitutional court judges because of the clear breach of the procedures, and about there's no finalities, and the nature of the decision that is a mere suggestion. So that means the court is according to many people, playing politics, or they call it a judicial coup d'etat. Anyhow, Yingluck decided not to confront with the court. She backed down and she proposed a series of amendments by section. So that was a more humble project that she wanted to amend the Senate, to reintroduce senatorial election. She wanted to simplify treaty-making procedures. But the court was very adamant. The court said that in addition to explicit unamendability, these are the constitutional identity of the 2007 Constitution. That the 2007 Constitution was drafted with the goal of imposing stronger check and balance. So the court argued that if both houses are elected, or if the government has more authority in making treaty without the parliament approval, that would render the internal check and balance within the legislation and within the cabinet meaningless. So that would be contrary to the constitutional identity, and the court said that this is an act to overthrow the democratic regime with the king as the head of the state. It was unconstitutional. There's another case, but it was thrown out because the coup happened and the junta abolished the constitution. So the court said that the case was moot. So that's it. So now let's move on to the very big question: why did the Constitutional Court not tolerate a coup? Oh. No, I put it wrong. But why did the Constitutional Court tolerate a coup? But why did it not tolerate a constitutional amendment? Well, there should be a not. Anyway, it seems like if there's still an element of democracy, the court is willing to impose a very harsh judicial review on constitutional amendment in order to safeguard democracy. But if there's no democracy left, the court turns into a very, I would say, very obedient facilitator of a coup regime. Because in contrary to the harsh review in the 2011 to 2014 period, under the coup government, 2014 to 2019, the court rarely raised its voice or scrutinized the coup at all. So the court was like two completely different court. At one moment, it was like very serious about safeguarding democracy, even go stretch beyond the text of the law. But for another moment, after the coup happened, it became a textualist. Anything that the coup said, the junta said, is law. So it was like legal and constitutional always. So that was like very perplexing. But if you look into the decisions from the 2011 to 2014, these decisions were read in the television, so everyone watched it. So one way it was like a public reprimanding of politicians, and another way it was like setting the narrative for what exactly is democracy, and what you can. So we all learn what the court's version of democracy is like. At the beginning of the court decision, the court said that they are acting according to a democratic principle. But what is exactly a democratic principle? The court said that democracy doesn't mean only an election and the majority rule. The court said, the court warned that election or simply relying on election can lead to the majoritarian tyranny of the majority and the parliamentary dictatorship. So the court said that there's minority rules, and most importantly, the court said that anything the government thus, even with the popular mandate, has to be in accordance to the rule of law. So there's a clear, very strong distrust in the majority's wisdom that the court repeat again and again that majority is not always everything, which is true in a way, but the way that the court just completely disregard the majority's voices, or completely disregard the popular mandate is no less problematic. Anyway, that distrust in majority's wisdom is the foundation of the idea what we know as Thai style democracy. So democracy that the court is trying to protect is not what we understand as liberal democracy, properly understood in a normal sense. It is a very peculiar kind of democracy that is called Thai style democracy, and you can call it like a relativistic method or relativistic concept. Thai style democracy originated from the 1932 democratic revolution in Thailand that ended the absolute monarchy. However, democratization and consolidation didn't take place firmly. There's infighting, the weak democratic culture, and within 15 years, the democratic force succumbed to the royalist conservative force. Anyway, they didn't turn back into absolute monarchy. It was already too late. So what the royalist conservative did was to propose an alternative narrative to liberal democracy. What the phrase that I repeat again and again, and the court repeated again and again, what they call the democratic regime with the king as the head of the state. So it was developed during the 50s and 60s under the military government in Thailand during the height of the Cold War. And it emphasized not on the majority or equality, but it emphasized the king as the head of the state and a hierarchical political structure with the king, which is justified. His position is justified by his moral high ground that the king is more preferable to civilian politicians because civilian politicians corrupt. And that is true because a weak democratic culture, you tend to get a lot of local strongmen who compete for power and enrich themselves. Anyhow, that was spun and would say inflated by the royalists to disregard or to undermine democracy as a whole, and emphasize on the role of the king as the head. It emphasized on unity over pluralism, which was regarded as a Western model, too individualistic and too divisive. If we accept pluralism, people fight. If we accept the king as the head or as a father figure and the whole nation unite, that would be fine. So by the way, when it developed further, it created a very peculiar situation where electoral politics exists, but in a very limited manner. So there's periodic elections, but rights and liberties remain very limited. The power, the real powerful figures is the king and the army. The army is portrayed as the guardian of the throne and the guardian of the nation. So it enjoys a moral high ground that precipitated from the king as well. So you will get periodic elections, but anyhow, if there's tension, if there's disagreement between all these powerful networks, the military will intervene and intervene by claiming to the higher value to safeguard the nation, to safeguard Thainess, ความเป็นไทย. Okay. So that's happened in 70s, in 80s. You get a lot of elections, but you get a lot of coup d'etat as well. So within 2 years, you get a coup, and there's a vicious cycle of coup election going on with the king, like above here. It changed in the 90s. The Cold War was over. economic and social liberalization, and it led to the 1997 democratization project that produced the 1997 constitution. So it introduced a very long list of rights and liberties, and it introduced many new courts and bodies like a national human rights commissions to enforce these rights. So that's the kind of liberalism that the project introduced. It tried to instill the sense of constitutionalism, placing the constitutional court as an arbiter of any political disputes in place of the king. But it clashed with the Thai style democracy. So the majority who's enjoyed their new rights and liberties, they clash with the network of royalists and conservatives who always enjoy the control in the politics. So that's kind of clash, and they try to resolve it this time differently. First, as they use the court, not the coup. So from 2006 in Thailand, we underwent the phenomenon called the judicial activism or judicial coup, where the court asserts the power to try to dissolve political disputes in favor of the conservative. But if it come to but if all come to the standstill, there's still a coup again. In 2006, there's a coup. In 2014, there's a coup too, after protect court challenges. So my last point is that this is not to, the court's action is not to protect democracy, is to protect authoritarianism and Thai style democracy, which is a euphemism for authoritarianism. My last point is the court's underlying message is the fear of abusive constitutionalism, that these politicians will abuse the constitution to dismantle democracy, so they have to safeguard it. But anyhow, I would argue that that fear of abuse is unfounded, because in the normal situation, the normal assumption is that the original constitution is democratic, and any change is undemocratic. But in Thailand's case, the original condition is already very undemocratic. And what Thai people try to do peacefully is to attempt to restore a more liberal democratic version. And the court said that no, the primary constituent power say that it shouldn't be so, and the basic constitutional identity say that it's against the original condition. So it's an uphill struggle, and that unamendability is actually blocked the attempt. This is an amendment of the future past, because right now we're back to square one again. The same situation, the 2017 constitution is very undemocratic, imposed by the 2014 coup d'etat. And what people are trying to do is to use their secondary amendment power to amend the one with the very undemocratic primary constituent power. There's a very interesting theoretical question, and very interesting to observe how that's going to play out, because the case is already in the constitutional court, and it will be decided maybe before this new year. So who knows? The big question: whose will does the 2017 constitution represent? Whose will the court gonna follow? And we will know in no time. So thank you very much. That's all.
Thank you, Kem Tong. That's wonderful presentation. And the idea that the idea of constitutional amendment is due to attack authoritarianism is quite interesting idea. So now I open the floor for questions and discussion. So participants, if you want to talk, please unmute yourself. So maybe I will go first with 3 questions for 3 speakers. The first question is for Koichi. It's very interesting presentation on informal constitutional amendments. Can you explain what are the arguments that the scholars use to contest the informal constitutional amendment? So what are their arguments? And you also mentioned on that, particularly you also mentioned on the idea of constitutionalism. And I learned that during 2013, many Japanese scholars used that notion to debate about the informal constitutional amendment by the government. Can you further explain on this idea? For Professor Lee, it's very interesting case about the decision on the amendment on judiciary or judicial independence. I'm just wondering, are there any political motivation, influence, or dynamic behind that decision? And finally, for Kem Tong, so just a very short question. Do you think by that, the court's decision on unconstitutional constitutional amendment, do you think the court tried to protect minority in that case? Okay.
Right, shall I start?
Yeah, Kochi.
Yeah, thank you, Son. Thank you for your questions. First, on the point about informal constitutional amendment and what arguments are being used against the informal constitutional amendment. Well, I think I need to clarify a little bit that even though there's been a history of informal constitutional amendment with regard to Article 9, in particular in the post-war period, ever since the time of the Cold War, for example, initially when the government took the position that self-defense force is constitutional and that Japan can exercise individual self-defense. There's been contestation coming from the public, also from the experts, legal experts, but I do not think that everybody regarded, for example, the existence of self-defense force as unconstitutional or the informal constitutional amendment to be illegitimate just because it's informal. So, you know, the revision, the kind of informal amendment of the Constitution through the change in the interpretation of the Constitution in itself is not necessarily seen or there's no consensus understanding that that is not permissible. However, the issue came really to the forefront with the 2014 interpretation, changing the interpretation in the form of the cabinet decision with regard to the lifting of the ban on collective self-defense. And that is because scholars and the public agreed that this was crossing the line. If you keep Article 9 as is, and yet start to argue that even Article 9 permits the exercise of even limited collective self-defense, then Article 9 is devoid of meaning. And other countries that do not have Article 9, of course, exercise collective self-defense. But if Article 9, at the very least, does not rule out Japan's exercise of collective self-defense, then it doesn't have any meaning left. Because then, of course, I guess Article 9 still bans invasion, aggressive war. But you don't need Article 9 to outlaw aggressive aggressive act of war. And therefore, Article 9, for it to have any meaning, I guess there was a huge majority of constitutional law experts and the public concurred that this was this was beyond the limitations imposed on what is permissible in terms of informal constitutional amendment. In relation to your second question about the term constitutionalism, becoming very widely used in Japan since 2015, also by the constitutional law experts in Japan. And actually, this is very true in the sense that many of us knew historically that the term constitutionalism was used in pre-war Japan. Japan adopted the first sort of modern constitution among Asian countries in 1889. And at that time, the Japanese ruling oligarchs after the Meiji Restoration, went to study in Prussia and adopted Prussian style of constitution. And at that time, even though the Meiji Constitution, in view of what happened with the rise of the militarists, because what is ironic in some ways that Meiji Constitution was also never formally amended, because it was a gift from the emperor to the people. It was a taboo to try to amend the constitution in the pre-war period, and therefore it has never been amended. Even though there were some arguments coming from the side of the Democrats that maybe it should be amended, that it needs to be clarified that the role of the emperor is more limited. But in the end, it was never to happen. In fact, the discussion itself was largely a taboo most of the time. And in fact, during as Japan got more and more into aggressive war, constitutional law experts were persecuted for having suggested that the emperor's power prerogatives are actually limited by the constitution. But so in the pre-war period, actually the term constitutionalism was widely used because those people who were in the side of the democratization of the Japanese political system protested when the oligarchs were seen to rule even beyond the constraints of the constitution. So in fact, pre-war Japanese political parties often had the name of constitutional this and that. And in fact, it's sort of ironic that now the main opposition party in Japan is called Constitutional Democratic Party of Japan. So what used to be the DPJ, it has now constitutional on top of it. And so a lot of constitutional law experts commented that constitutionalism was largely a pre-war term of discussion in Japan. However, under Abe, it became a mainstream terminology again in the post-war era, more than 70 years after the war ended. And this is the extent to which people are alarmed that the current government, which has been succeeded by Suga, but largely unchanged from Abe's time, seems to neglect the constitutional constraints imposed upon the executive branch by the written constitution. And that is what is often meant by constitutionalism, that a modern constitution would have to have at least a set of Bill of Rights and clear constraints imposed on the state powers. And if the state power can arbitrarily change the interpretation of the constitution and lift a ban on collective self-defense, for example, then the constitution does not have any real significance. And that is a breach of constitutionalism. Thank you.
Thank you. Professor Lee?
Son, could you repeat your question to me, please?
So are there any political motivations and dynamics or influence behind the court's decision on the amendment regarding judicial independence?
It's very hard, to speculate on whether the judges had any political considerations in mind. I think basically unfortunately, the factual scenario was one where it wasn't controversial in the sense that it dealt with the challenge to the validity of legislation in which the calculation or the assessment of compensation for the compulsory acquisition of land was determined by a panel of a judge and 2 assessors. And as a result of the amendment to the statute, where the judge may differ from the other 2 assessors, the decision of the 2 assessors would prevail. And when you look at it from that viewpoint, if the determination of the Compensation Assessment Board is the exercise of a power which you describe as a judicial power, then you have a situation where the statute empowers the judicial power to be exercised by a non-judicial entity. And I think the Apex Court in Malaysia decided to reaffirm the proposition that judicial power could only be vested in the federal judiciary and exercised by the federal judiciary. And I think that particular case didn't carry political a political context behind it, but it provided the opportunity for the court to engage in the reception of Indian basic structure jurisprudence into the Malaysian legal arena. And because that case didn't carry political implication, and because the court did not go to the extent of striking down the amendment to Article 121 of the Constitution, which had changed the vesting of the judicial power, it didn't yield a sort of outcry against the judiciary. And I think in one sense, it was quite a adroit maneuver on the part of the judiciary to restore its own preeminence in the separation of powers doctrine. Apart from that, I doubt that I can speculate more as to whether there were any political motives behind that particular decision.
Thank you, Professor. Kem Tong?
Yes, indeed, the court was trying to protect the minority, but this is not the minority in the conventional sense that is vulnerable to the majority's abuse, like a religious minority or a racial minority. Actually, this is a very powerful minority. There's what Duncan McCargo's term as a network monarchy, the monarchical network, or what Eugenie Mario termed as the deep state. So there's a network, a vast network of bureaucrats, the king, army generals, and big businessmen that has dominated Thailand from 1950 in the form of military government, in the 70s in the form of what they call a hybrid regime, and from 2006 to 2006, and then again from 2014 onward. So you will see that actually this is a very powerful minority. There's only a brief period of liberal democratic government that ruled by the majority. That's only after, in the 90s, especially after the year 2000, by the 1997 Constitution, and that hope was dashed in the 2006 coup, which is like a watershed year, and after that year, the democracy in Thailand just went downhill. So yes, protecting the minority, yes, but what minority? There's more subtle to the term. Yeah.
Okay, thank you. Rehan?
Thank you, Song. Thank you all again for really excellent and provocative papers. I have a question for HP and then a couple of questions for Kem. So HP, you were kind of suggesting this in your response to Songs. Maybe I can just push it a little further. But there are kind of two things that struck me about the Malaysian decisions. The first is, going off what you said about, they didn't actually strike down the amendment, they just kind of read it down. Is that really such a big deal? I mean, the Privy Council in the 1960s did the same thing in Dominion Ceylon, right? There's the famous case Bribery Commissioner versus Ranasinghe, where the Ceylon government tried to create a bribery commission and give it judicial power. And the Privy Council said, no, the judicial power is vested in the courts, right? So I wonder in that case if they're just kind of reading the Constitution as written and, just kind of citing the basic structure doctrine for extra support, as opposed to really entrenching it. And then a kind of related question about, the subject matter. And you said this a little bit in your response to San. I'm a little skeptical when courts issue the basic structure doctrine to protect their own interests. In this case, I think it was good, and I'm glad the Malaysian court did it. But that again leads me to question whether they're actually going to invoke this doctrine for something that doesn't involve their own power. So you mentioned the rule of law. You can imagine like maybe even a separation of powers issue that doesn't concern the courts themselves. Do you think that they're likely to use the basic structure doctrine there, or are they just going to use it when their own turf is threatened? So that's a question for you. And then Kem, I really liked your paper, and I totally take your point that the court has been abusive, right, in the way that Landau and Dixon write about it. It's abusive judicial review. It's upholding the power of this kind of minority. But I wanted to push you on a couple of specific things. So you mentioned in your paper a series of amendments that Yingluck's government tried to do. And so some of them were so some of the court's decisions to me were very obviously anti-democratic and some of them weren't. So the one about the Senate direct election, to me that your argument was, I don't know how you can even argue against that, right? Obviously the court was stepping in against democracy. But I didn't sort of understand how that works in the treaty power, for instance, right? I mean, you could imagine a situation where, a government like Yingluck's, which has a lot of power, just wants to accumulate more power. And one way to do that is to push the legislature out of the treaty-making power, right? So it wasn't obvious to me how that was necessarily anti-democratic. And then that pushes me to a kind of broader question for you, which is, yes, we don't want what you call Thai-style democracy, but we also don't want just majoritarianism, right? And even if Thaksin and Yingluck are better than the alternative, they're also deeply problematic. So what's the solution? And this is the tougher question, I guess. Do you think that there can be a new constitution that can both constrain the excesses of a Thaksin and keep the military pro-royalist faction at bay? I mean, it just seems like they're so at each other's throats and both sides are pretty ruthless that I'm just not sure what a new constitution would accomplish. I know that's a very kind of skeptical question, but I'm genuinely curious because I do follow Thai politics a little bit, and I guess I don't see how you get out of that.
So Cam, can you go first?
Oh yes. All right. Okay. So, yes. So I agree with you that in some cases there's an evidence that the government tried to usher the amendment motion through the parliament. So they try to acquiesce or silence the opposition, and the court cite that as a procedural flaw of the amendment as well. So yes, Yingluck is not an angel, Thaksin is not a saint, for sure. I mean, both sides right? But yes, for the treaty-making power, so it requires some context that Thaksin had entered into many FTA agreements, which upset a lot of conservative, especially from the agricultural and more conservative factor. So they try to say that any treaty that has an adverse impact, socio-political impact, has to require approval from the parliament. And no one at first, no one knew what it was, but then there's a case with Cambodia, the Previer case with Cambodia. So the government didn't foresee any protest, and no one, even Cambodia, didn't foresee any protest. But the anti-Thaksin faction thought that it was a very good opportunity to stir some nationalistic sentiment. So they drum up and it became an armed conflict. So the court said that even if the government didn't foresee, if the treaty by the court's own addition into the decision, saying that if it didn't have an adverse impact, but it may have adverse impact, the government was at fault. So that kind of like shocking, not only to the government, but for the Ministry of Foreign Affairs as well. So not only politicians didn't like it, it cost them one government and one foreign minister, but the civil servants in the Ministry of Foreign Affairs hate it as well. So there's a call for like back to the same to the 1997 model, where you still require approval in case that treaty would alter the integrity of Thai's border or Thai sovereignty. So there's already check and balance in place, but the clause is so imprecise in the new constitution that it causes trouble. It has real life implication. So you could say that Yingluck's amendment agenda is partly to go back to the 1997, but partly as a revenge to what did unto her party in the 2008. So she want to symbolically rectify it. It was very clear in the third case that that got thrown out from the court, that was purely just that's what a pure revenge for their supporters. So that's for the treaty making. For the prospect of new constitution, as I say, both sides share some guilt. Yes, but in order to decide the new constitution that constrain both the military and Thaksin and Yingluck, both parties has to start negotiation, start a dialogue, and that we haven't seen it happening yet. The government pushed to its version and discard the version that the people submitted. There's more than 100,000 people signed the petition, and the government said, no, we're going to go with Prayut, the junta's version. So that dialogue hasn't taken place yet. So the chance of the new constitution, yes, we're going to have a new constitution. Is that going to be the new constitution? I don't think so.
Okay, thank you. Professor Lee?
In responding to Rehan on the first aspect, as whether is there anything wrong with the fact of reading down, isn't it? The constitutional amendment. Well, I mean, you refer to the bribery commission, Rana Singhi's case, and you refer to the decision of the Privy Council. But the Malaysian judiciary is not in the same situation as the Privy Council, and I would have agreed with you if the opportunity provided by the change of government in 2018 had led to major reforms to the procedure for the appointment of judges and chief justices. That opportunity was wasted, and basically the power appointment is still in the hands of the government of the day. And looking at the history of the judiciary in Malaysia, there have been in the past some chief justices who are prepared to defer considerably to the government of the day, perhaps in the anticipation of better prospects. And therefore, I would say that if given the opportunity to strike down the amendment to Article 121, the court should have seized that opportunity to do so. But your view, I mean, is supported by other people like Professor Yvonne Tew, who in her most recent book appeared to suggest that the court must show some degree of political acumen and adroitness in the maneuvering the political minefield, and therefore stopping short of invalidating the amendment might be one exhibition of political acumen on the part of the judiciary. But it's a matter of speculation anyway. On your second point about whether the court reached the decision about the basic structure doctrine being applicable in relation to its own interests because of the divesting of the federal judicial power from the judiciary, the court provided the examples of the rule of law, the separation of powers, judicial dictum in the protection of minority rights. But I am not actually in the position, and in my paper, as I had discussed with Andrew, I was not trying to determine what are the attributes of the Malaysian Constitution which would fall within this basic structure doctrine. I think it will have to be, as the court has said, on the case-by-case analysis, looking at the circumstances of the case and in the context of the arguments put before the court. I mean, it can be argued by many people, for example, that the Constitution intended the Malaysian nation to be a secular nation, right? And if that is so, then is secularism a basic feature of the Malaysian Constitution? But to counter that, the Constitution said that Islam is the religion of the Federation. And therefore, there are these contestable ideas as to, in terms of religion, regarding the basic feature of the Constitution. Now, the Malaysian Constitution has this special institution called the Conference of Rulers, where the hereditary rulers, make determination and have the discussion about the policies of the government of the day, and they do carry certain special powers. Could one argue that the Conference of Rulers is an entrenched feature which shall be there forever and shall never be altered? Again, views here may differ as to the future, where new generations of Malaysians may regard this institution as no longer a necessary feature. So I have now tried to speculate on what are really the essential features of the Malaysian Constitution. All I did try to establish in my paper is that there's now a clear adoption by the court of the basic structure doctrine in Malaysia. To what extent it will apply this doctrine to other aspects of the Constitution is a matter, I think, of speculation. That's my only response to you, Rehan.
Thank you, Professor Lee. So we have 6 more minutes for this panel. Any other questions
Andrew
or comments?
has a question.
I
think Andrew Harding has a question.
Andrew?
Okay, thank you very much. 3 terrific papers. Thank you very much for the enlightenment and a fascinating discussion about basic structure doctrine moving forward from where we are. And I just really wanted to comment on I'd originally thought of questions, but I just really want to now comment on the exchange between Rehan and HP, and also between Sun and HP on the issue of the political angle. And let me say that HP and I have been discussing these issues for, I think, at least 40 years. So we're not likely to be in severe disagreement at this point. This is an interesting question about reading down versus striking down. And I think this may become very, very important moving forward now that we seem to broadly accept, in many countries, the applicability of basic structure doctrine. And I don't actually think that it's quite as trivial as Rehan is making out. I mean, if, for example, using HP's case of Article 150, Clause 8, the ouster clause in Article 150, supposing the courts are going to in effect sort of say, well, this clause simply does not have the effect of ousting judicial review in a case like the one at bar, maybe with some rather kind of extreme use of emergency powers. Then reading the constitutional amendment down might actually be very effective. And it's not just a matter of reading down, it's reading down in the light of the basic structure of the Constitution. So I think this actually could be quite a powerful weapon, and it allows the judges, a sort of a safer landing, a softer landing than simply striking down the constitutional amendment, which is fairly dramatic. And maybe the same sort of thing with the amendment, the Malaysian amendment to Article 121, which is the one about judicial power. In effect, you can here render a constitutional amendment pretty much nugatory. And that doesn't seem to me a bad thing. Now, coming back to Sun's interesting question about the political background of this development in Malaysia and HP's interesting response to that. I mean, surely, absolutely, there is a political background to this, because what you can see since 2007 is a sort of a gradual reassertion of judicial power in the Malaysian system. And this really goes back. This may be, not familiar to many of you, but there was a famous matter of the Lingam tapes in 2007, which revealed sort of massive and disturbing interference in the process of judicial appointments. And that created a sort of a backwash of demand for reform of judicial appointments, which was forthcoming, the Judicial Appointments Commission Act 2009. And I think what we're now seeing is a kind of a knock-on effect of that reform, because obviously it's the judges at the highest appeal level that have the most effect on these issues, not the judges immediately just appointed in the High Court. So it takes about 10 years for such reforms to actually make an impact on the judiciary. And I think that's the impact that we are now seeing. So I think it's not so much the political orientation of the judiciary, but it's more a matter of releasing the judiciary from this kind of horrible backstory and allowing them to do the job in the best way that they can imagine. So there is politics in this, but I think it's not quite the politics maybe that you were expecting. Anyway, that's just a comment. Nobody has to respond unless they want to.
Andrew, can I ask a follow-up? Just that's very interesting. So I wasn't meaning to suggest that striking down is much worse than or trivial compared to
reading down.
Reading down is trivial compared to striking down.
Yeah.
I was more sort of making the point that and you know much more about Malaysia than I, which is why I'm asking. I don't see the work that the basic structure is doing. That is to say, if the Privy Council could have done pretty much the same thing, just relying on Jennings' manner and form and some common law tradition, it seems like, and you sort of suggested this, they're using it more as a kind of soft landing spot. And then the question is, why is the basic structure the thing that they need for that? Is it that Gopal Sriram still exerts some kind of overall influence where they care about India? Like, what is it about the basic structure that's necessary there? Like, you could get to the same decision without it. That was my sort of point there.
So yeah. Do you want me to respond to that,
well,
or
HP? See why you think the basic structure. I'm just curious as to the kind of judicial politics of Malaysia, why that's the one that they cling on to.
Okay.
I defer to Andrew.
Yeah. Okay.
Okay, thanks. Yeah, well, I mean, yeah, this is a very interesting point. I mean, it does seem to me that the basic structure doctrine, nonetheless, has this kind of impact by a sort of side wind, even though you don't have to use it. The fact that it's lying around there, and you can use it, and you do in fact use it, and it sort of bolsters your decision in terms of constitutional interpretation, well, that seems to me quite a significant impact of the basic structure doctrine. And I think the actual, the consequences of these decisions are by no means trivial. I mean, they are,
certainly,
they are absolutely fundamental to the whole. You may say that through 2 or 3 decisions in the last few years, you could say that the entire interpretation of the Malaysian constitution has been altered. I mean, I wouldn't put it 1 cent less than what I just said. So I think it's a pretty important development. But point taken, Rehan. I mean, you could, I suppose, in theory, if you didn't have basic structure doctrine, you could still achieve the same result. But I think it's important that that isn't really what happened. They did use basic structure doctrine, albeit in this sort of rather limited way of, using it as a tool of interpretation. And let me just add here that exactly the same thing has happened in Singapore. I mean, it's one of those in the category that you outlined of where they discussed basic structure doctrine. They haven't yet applied it. But they have used it as a tool of interpretation. So it's not just in Malaysia.
Okay. So thank you, speakers, for your wonderful presentations, and thank you, participants, for your very engaging. We're in this very brilliant discussion. So thank you, everyone, for joining us in this panel. So we need to stop this panel here and see you next panel on our distinguished speakers on commentaries on this particular interesting topics, and see you at 7 p.m. See you.